A moot is a form of advocacy. It's a form of advocacy that lawyers actually rarely themselves get to practice. Most lawyers practice, when they go to court in trial, they're there to try to find facts. We're at trial because parties don't agree what happened, and most of our time is spent trying to find out what happened and make submissions on the facts of a case. In a moot, the facts are not the problem. It's the law that's the problem. The law didn't envisage these facts, perhaps there's a gap in the law, or there's been an inconsistent application of the law by different judges in the past. But what many people do is get obsessed by the law and forget the common factor between the moot and every other form of advocacy, which is that you have a client. You have a party who cares about the result of the case that you're arguing over. It may be that their money is on the line. They will be better or worse off if you win or lose this moot. Maybe their freedom is on the line. They will be free if you win, they'll be jailed if you don't. It's that important to them. Maybe there's a child on the line, and who will look after a child? Maybe the subject matter of the moot. It may be their employment is the matter that's under discussion. But you've got to remember, you have a client who cares about the result of this case. So the essential balancing act that defines the moot is the fact that you are there to assist judges with the law, but trying to get a solution through the law for a client who is there and banking and depending upon you. It stands to reason then a moot is legally complex. It's meant to be so. Sometimes the facts in a particular case are unusual. That is why the law has been challenged, because the facts were not predicted or anticipated by those that made the law in the first place. So you may be submitting that Parliament, whilst intending to achieve a desired outcome, didn't actually manage to specify what to do in a particularly difficult situation. It may be that judges in the past, in trying to rule on how to enforce a piece of law, have done so inconsistently, maybe even erroneously. All of these add to complexity. Let's take a little example. One of the currently very difficult areas of law is privacy and how to protect people's privacy. No one really thought about the implications of Twitter and other sites like that, and the fact that people could post information about each other anywhere in the world on a site like Twitter. So we now have a situation where we have complexity and difficulty. What a moot is about and what makes a good mooter is someone who can make light of the complex. Someone who can find a simple, elegant and practical solution which will turn complexity into simplicity. The great skill of the mooter then is someone who can see what the real heart of the problem is and find an easy way to bring sense and rationality to a potentially difficult situation. A good advocate always has a lot to say, but a great advocate doesn't need to say too much because they get straight to the heart of it, and their solution is all about simplicity, rationality, and elegance. And that is what you always need to be aiming for if you can, whenever you do a moot problem. The first error, and one you see a lot, and one which is almost fatal, is the mooter who is not clear what he or she wants the court to do. You've got to get this right. This is your application. The court are there at your request, and you are asking them ultimately to do something for your client. You've got to know what you want them to do. You've got to be able to say what findings you want them to make, what law you want them to apply, what law you want them to disapply, why you want them to apply it. If you can't tell them what you really want from them, you're in real trouble in the moot. Too often, a mooter will say, can we just discuss this topic and can I take you to this particular authority? And the judge will say, well, why? What is it about this authority you want me to conclude? What do you want me to do? So now we get to the idea of the word submit, which is a fundamental one for any lawyer and for any mooter. You will be making submissions. And your submissions are your arguments. You need to be clear what your arguments are, because ultimately those submissions are the things that become the court's findings. Now you hear many lawyers saying, I submit that the case of Williams and Roffey applies in this case. That's fine. Now what they're effectively saying is they want the court to find that Williams and Roffey applies or doesn't apply in this case. If you want to be smart, you can even change the language, and rather than always just saying, I submit, I submit, I submit, you can turn it around and say, the finding I invite the court to make is this. You need to be able to identify, distill, and say clearly what findings you want the court to make. If at any point the court is not clear what you want them to do, what findings you want them to make, and what declarations you want them to make about the state of the law, you will not be a practical or successful mooter. This next point's an important one. It's very tempting when you've been in academia for a while to get into an academic process. Now what I mean by that is that I know from when I was an undergraduate, what I would do when I wrote an essay is review data, discuss data or other people's views or opinions, and ultimately come up with a conclusion, i.e. I would save my conclusion for the end. And I think a lot of people, when they are studying, do it that way. Now, this is not a piece of academia, this is practical advocacy, and the judges will not tolerate it if you leave your conclusions to the end of your submission. Actually, they'll want to know at the start what your submissions are. So it's critically important to get into the mindset that you start with what you want and then you go on to explain why you want it or why it's the right thing to do. So as always, lead out with your submissions. So you would say very clearly, very plainly, I have, whatever it is, 4 submissions. The first of which is to try to persuade you that, and you make your declaration. Then you'll explain why that is the right finding to make, why that's the right interpretation, and you can cite common law, cases, statutes, common sense, the intention of Parliament, or whatever it is. But that is all support for the submission. The submission comes first, the support for it follows. The next vital point is to understand that there will be interaction between you and the judge, and you've got to engage your judge or judges. Remember what's going on. You are making submissions. The court, if they accept them, will declare that your view of the law is right, and that will bind all other junior courts in the future. You're making law. It's terrifically important, and the court will want to talk to you about what you propose that they do. So be ready to expect intervention, welcome intervention, and if you're really good, you'll actually encourage it. Here's how you might do it. Firstly, you need to ensure that the judge knows what you want from them. So share that with the judge very early on in a collaborative way. My lords, this is what I'm asking the court to do. If there's a process involved, share that with the judge as well. My lords, the process by which your lordships would arrive in my submission at the ideal judgment will be to follow the following steps. Firstly, I'd invite your lords to do this and that. So you share with the court what you want them to do and how you want them to do it. That will encourage the judges to get involved and see that this appears to be a piece of collaborative work. Now, I could talk for hours about structure. I shall try to keep it brief. All right. We've indicated that what we're dealing with is complex. The whole point of a moot is that there is legal complexity. If you're trying to express reasonably complicated ideas, the structure is critical. If we lose where we are in your explanation, everything else falls apart. So it's always structure, structure, structure. Most moot winners, I have to say, are not the ones who are legally strongest. They're actually the ones who are structurally strongest because they get the best value out of the points that they make. Now, there's a lot to say about structure, but let me just say the most important thing. There are 2 forms of structure which we've got to keep the judge and court aware of how we're going and where we're going. It's the idea that you have parallel arguments or arguments in series. Let's take series first. Let's take a really simple civil case. Take a case in negligence. You have to prove a number of things in series. You first have to prove that the relationship between two people where a duty of care arises between them. Then and only then can you go on to discuss whether or not there's been a breach of that duty of care. If there's been a breach, you go on and say, well, has there been loss? If there is loss, you look at whether or not the loss was caused by the breach and whether or not the loss was foreseeable. So do you see, there's a pattern you'll be familiar with, that we go through a cause of action, ticking off each stage in turn. Now, that's what I would call an argument in series. You have to show a series of things, and they are all consequent upon one another. Now, the series of arguments that you need for a tort case is straightforward. You get to a moot problem, and the series of arguments that you need to get to the ultimate conclusion will be less familiar to the court and will need more careful handling. But the court must know where along the chain you are. And if the judge loses where you are, it's really the end of you being an effective advocate. So you need to do what we would call signpost. You need to signpost how many steps there are, which step you're on, and when you finish that step, to be clear that you're now moving on to the next step on the assumption that the earlier argument has been accepted. That is not the only type of structure. Within each step, you may want to say there is more than one way of passing through that step. You might therefore want to present alternative parallel arguments. So you might say that in order to meet step 1, you are making the court an offer of 3 submissions, any one of which would fulfill that step. So you're making offers of alternatives, and I would call that arguing in parallel. Now, if the court haven't picked up you are offering 3 parallel alternative arguments, they'll simply lose where they are, and again, the structure of your application will fall apart. Let me give you an example. That's probably the easiest way to do it. Let's take breach of confidence as an unusual tort. Let's imagine a CCTV operator has been secretly CCTV filming a celebrity out and about, and has then decided to try to sell those CCTV images to a newspaper. Now, let's just say, I'm not an authority on this area of law, but let's just say that you think the law is in 3 stages. Firstly, you've got to show that the information received by the operator is private or confidential. There is then the next step, which is that the operator must receive the information in a situation where they are not being expected to pass it on to other people. And then the third declaration you need from the court is that protecting that person's privacy is more important than the freedom of speech. So that might be, for example, in a moot problem, the 3 sequential steps that you need to pass through. But then you might say under the first step, for instance, there are different ways that the court might come to the conclusion that the information is private. So under the first of 3 sequential steps, you would want to make alternative submissions. And this structure has got to be signposted so the court can follow exactly where you are. We've indicated already that a moot is bound to be complex. Your arguments may be brilliant, but if they're not well structured, the court simply won't follow them as well as they should do. So the secret to mooting is structure, structure, structure. And I want to introduce 2 structural ideas to you, along with the idea that structure needs signposting, i.e. you've got to tell the court what the structure is and where you are within your structure as you make your way through your application. So the first structural type I'd like to talk about is what I would call sequential arguing. The idea being that you must satisfy a number of arguments in series. all consequent upon one another. Let me give you an example of what I mean. In a simple tort case, I'm sure you'll be aware that you need to prove a number of things in turn. First, you've got to establish that there's a relationship between two parties and that a duty of care was owed by one party to another. If you don't prove duty of care, that's the end of the case for you. If you can show there's a duty of care, you've then got to show there's been a breach of that duty of care by a negligent act. If you can show a breach by a negligent act, then you have to show that loss was caused by the negligent act. If you can show loss has been caused, you then show that the loss was the cause of the negligent act, and so on and so forth. You'll be aware of these systems that are set up in our legal system. Now, if you've got to take the court through 1, 2, 3, 4, 5 steps, it stands to reason the court have always got to know exactly where on this process you've got to. In a moot, the process is likely to be one the court haven't come across so often because it's such an unusual or difficult area of law. So what the right process is much less familiar than in the example I've just given you. So you'll need to educate or persuade the court what you think the correct process is, and that will need some care in how you explain it. The second structural type is not arguing in series, it's arguing in parallel. It may be that you want the court to arrive at a particular conclusion, but there's more than one way to get there. And what you might do is be offering the courts, let's say, 3 different routes to the same conclusion. Now again, the courts must understand that these are alternatives. The courts only need to accept one of the 3 options that you're giving them, and once one of the options has been satisfied, then they can move on. And that is obviously a different structural look than arguing something in series. So for instance, you might say, my lords, in order to arrive at this conclusion, I make 3 alternative submissions for how your lordships could justify making that finding. The first would be to find that that's what Parliament intended. The second would be to read the case of Smith and Jones in a particular way and accept the reasoning in that case, or the third would be whatever it is. So the idea is you are making alternative offerings to the court to get to the same conclusion. Now, where cases get difficult is where you've got to argue both in sequence and in parallel. You may have to jump through 5 or 6 sequential steps, but one step would be satisfied by different alternatives. And if the court can't follow how you are arguing and how which arguments fit which step of the argument, they'll just lose where you are. So the best mooters and the ones who tend to win, I have to say, are those simply that keep their logic of the structure in the forefront of the court's mind. So the third thing that you can do is to encourage the judges to actually intervene and direct you. An expression you hear from some established advocates, and it's a very nice one, is to say something like, unless your lordships direct me otherwise. So for instance, if you tell the judges that you have 3 arguments, any one of which would mean you would succeed, you can then say to the judges, my lords, I intend to take you through each in turn, this one, then that one, then the third one, unless your lordships direct me otherwise. And then the judges can engage and go, well, we don't really want it in that order. How about you do that third point first? That's the one we think is most interesting. Then you say, of course, my lords, and you do as they bid. So if you offer yourself to be directed by them, then you will really find as a good communication will develop between you and them. I recall the last time I was in the Court of Appeal, I had 9 points to make, and I'd actually put them in a skeleton argument, and I showed the Court of Appeal skeleton, of course, before we came in. I said to them when I arrived that I was proposing to take them through each of the 9 points in turn, unless they wanted to direct me otherwise. And they said straight away, yes, they had decided they'd agreed with 8 of the 9 points, but there was one point they didn't like at all, and they wanted to have a good row with me about that one, and that was great. We took away all the other 8 points and discussed the ninth one at their request and at their convenience. So an advocate who can adapt and allow the court to push them into the areas of their submissions where the court is most keen to discuss and delve, that's a sign of a good advocate. It's important in any piece of advocacy or any form of performance at all, I think, to try as much as you humanly can to enjoy what you're doing. It's really important. If it's a nerve-wracking ordeal for you, it's probably not that exciting to listen to. So people I know are overcome by nerves, that's natural, but enjoy the adrenaline of the situation. Enjoy as much as you can that people are listening to you and want to know what you're there to say. So a lot of this is psychological, and as much as possible, try to embrace the fact you're speaking publicly and that you have an audience. Imagine if this were for real. Imagine that you really are in the Court of Appeal or in the Supreme Court, and you are making submissions on what the law should be or what the law is if properly interpreted. And if what you say is accepted by the courts and the courts agree with you and declare your thoughts as being the court's findings, you are actually making English law in a roundabout way. And that should fill you with pride and ambition and a sense of desire and adrenaline and excitement to try to achieve that through what you say. If that sense of desire and anticipation comes through in what you say, you will be so much more interesting to listen to than if you go into your shell a little bit and are just concerned about your own nerves.